number 29, the people of the state of New York versus Trevor Anderson.
May it please the Court, Alex Down of Appellate Advocates for Appellant Trevor Anderson. With the Court's permission, I'd like to reserve 2 minutes of time for rebuttal, and also with the Court's permission, I'd like to continue discussing the PowerPoint first. Would it
Continue discussing?
Would it be all right if I started with point 2, the
Yes,
PowerPoint discussion?
Of course.
This case also involved alterations of trial exhibits by the prosecutor outside the presence of the jury, displayed to the jury during summation on a critical issue that went to a key issue in the case. In this situation, the most egregious exhibits were the complainant's medical records, which nowhere stated that the complainant had been shot 4 times. They had indications of 4 wounds. They never said that the complainant had been shot 4 times.
Welcome back. On the PowerPoint, is it your position if they weren't doing a PowerPoint, if they just came in with the exhibit enlarged but already marked up, could they do that? Or is your position they can only point to it or put labels on it, whatever, stickums, whatever you want, when it's physically first shown in the clean exhibit format that was admitted into evidence?
Our position is that they definitely can't do anything outside the presence of the jury and then bring it in marked up. And
Okay.
I wouldn't even go so far. I mean, I would...
Regardless if it's a PowerPoint, doesn't even matter that way.
PowerPoint, not PowerPoint. You
Doesn't
can't
matter.
bring in a trial exhibit that's been marked up, not say anything to the jury like, I marked up the exhibit. The court doesn't give an instruction. In this case, defense counsel doesn't object. I understand that the medical records were made available to the
But
jury.
if you come in, but is your position, if you come in, the exhibit enlarged so people can see it, and then you mark it up in front of the jury, is that okay?
If we're talking about this exhibit in this situation, absolutely not. And anything
Why
I might have
not?
said so
Why
far
not?
today that suggests...
Why not, counsel?
Well, in this situation, because the prosecutor is literally changing the meaning of the medical evidence to make it seem as if it supports his theory of the case when it doesn't. The medical records said 4 wounds. They never said 4 gunshots. The people never said they said 4 gunshots. So if the prosecutor walked in with a clean version of the medical records showing 4 wounds, 4 wounds.
You know what I wonder? Why is that important? If this person was shot twice or 4 times, does that affect the outcome of this case at all? I mean, is it really important? Or I see your point in terms of alteration. Okay, in other words, it's arguable that he was only shot twice rather than 4 times, and I tend to think that probably is what the truth would be. But leaving that aside, one way or the other, that's not really the key part of this case, is it?
Well, the prosecutor thought it was very important, and in the prosecutor's summation...
Sometimes they're wrong about that. You know, that they aren't necessarily right about what they think the key part of the case is. From your appeal point of view, the thing that jumps out at me is not that at all. Because whether he shot 2 times or 4 times, the person was shot, and it seems to have some strong proof against the defendant here that he actually did the shooting. So whether it went in 2 or 4 times, okay. Isn't this, the real question here is the ineffective assistance of counsel? Isn't that the real issue?
Yes, I see them as, yes, Your Honor, I see them as interrelated because the more important and more egregious, more relevant the misconduct was, the more clear the ineffectiveness. But I would just say, in addition to the prosecutor relying on the 4 versus 2 in his summation to make the intent argument, the jury also thought it was important. So the jury asked for the definition of intent during deliberations. So clearly something good was going on with, have the people proven that the shooter intended to kill as opposed to injure.
I understand your argument, but what leaps out at me are slides with a biblical text saying, the wicked flee where no man pursues, but the righteous stand steadfast as a lion. That certainly wasn't put into evidence. And yet
Correct, and nor was the target.
Or the target, but it was put on top of it. And there are a number of instances. There was witness testimony superimposed on trial exhibits, biblical quotes superimposed on evidence. There was a court charge given a reference to what the law was. There was a rearrangement of the hospital progress report, which is what you're talking about, in the form of a slide, which is different than the evidence itself. and the rest photograph, of course, itself. But there were almost 80 exhibits that we went through here, but those are the ones that kind of leapt out at me.
The medical records, the phone calls were redacted. The sheets showing 38 phone calls redacted, all but the
None
two.
of this was objected to.
None of this was objected to, and not only was none of it objected to, but defense counsel made a record of the fact that he knew a
So
power...
let's say this, let's say we don't apply your bright line rule, and we're into an abuse of discretion standard. How do you argue that in this context, assuming that you get past ineffective assistance of counsel? See what I'm saying?
I'm sorry, I don't...
That's all right. Assuming that we don't apply the Washington State rule, it's per se reversal. We're saying no to you on that. We have a previous case, the same issue. And so now we're into whether or not there was an abuse of discretion here. That's where I would look to focus your argument.
You know, I'm still missing...
All right,
Are
so
we
the
talking
po-
about
The
the
exhibits.
courts?
Yeah, the court's ruling, the exhibits. There was no discretion exercise here, was there? The court made no
By
ruling.
the court did not exercise any discretion in keeping from the jury altered evidence that was not introduced in that form, or from... Is this what you're...
Yeah,
the
go
question?
ahead.
Or from protecting the jury from highly inflammatory closing statement in which the prosecutor told the jury, you're looking at the face of death, while displaying a photograph of the defendant that had been altered to show, altered with evidence circled around his head, very much like looking at him through the scope of a gun or a target, and basically giving them the message, get him. Don't carefully sift through the evidence and figure it out if the people have proven their case on every element of every crime. Just get him because he's the face of death.
On that quote-unquote target photo that you were just talking about, the mugshot of the defendant went into evidence, right?
Yes.
So here we are again, something's gone into evidence, and it's words that are put on that copy of the photo that is in evidence that the jury is only going to see in the courtroom, not in the jury room, right?
Correct.
That's what we're talking about. Okay, and you say it's improper to have put those words around that photo because you say it looks like you're looking at him through as a target through a lens, like a gun, right?
That's what makes it harmful. That's not what makes it an error. What makes it an error...
But the prosecutor could have taken the mugshot that was put into evidence and held it up and said at the top of his head, these words, around his ear, these words, around his ear, these words, around his ear, these words. That would be okay?
Without visually altering the exhibit, the prosecutor could have...
Are we not giving the jury any credit at all by saying that, because they see something visual like that? Isn't that the argument that was made about, for example, crime scene photos? We want to keep those from the jury because they might appeal to the jury's sense of emotion. We can't show them that they're too horrifying, and yet we've decided long ago that those photos are available to the jury.
I think there's a big difference between deciding whether or not to show the jury actual evidence that they can evaluate that's relevant to an issue and is admitted in a certain form and the foundation has been laid, and trusting them to determine that what they're being shown by an officer of the court during summation and what appears to be a piece of evidence actually isn't. I think that those are two very, very different things. And given the outsized impact of visual information on jurors, I think that we need to...
If the prosecutor said beforehand, I'm going to show you that this is exhibit, whatever it was, exhibit A, but I'm going to make some arguments for you that I'm going to have written on here, but you'll have the exact exhibit that was admitted into evidence without these words, that would not be okay?
Well, I was asked this question in the last argument,
Right.
and I said maybe, and now I'm going to say no. But it's
Well, I figured you would.
it's now that I get to do it again, I'll say it's just never appropriate to alter trial evidence and show it to the jury in an altered form. And I would just say that it's not as if we have some big problem we're trying to solve. I mean, prosecutors have been able to point to evidence in all the ways that the prosecutor discussed without creating these problems. So if technology
But you're
is going...
seeing it as a problem. You're saying it's a problem, and it may not be a problem.
What I'm-
That's what we're here to decide, isn't it?
Well, what I'm saying is to point to something in order to draw the attention of other people to it is not difficult. But if in creating the pointing outside the presence of the jury, there is the possibility of confusion, that's a problem that's very avoidable.
Now your rule, though, would be in a defense summation as an eyewitness, and the defense lawyer wants to put up boxes like this saying failed to identify on stand, failed in prior line. They can't do that either.
The defendant is on trial, so he has protections.
So there's different slide rules for a defendant?
We don't have a defense PowerPoint presentation in this case, and I
But we
don't...
might in the next one, so what's the rule for a defendant's PowerPoint slide?
If a defendant...
They're
if a-
altering evidence.
I don't think that it would be a good practice for any attorney to actually alter trial evidence and display it to the jury in a summation.
But would it be the same rule? You can't do it?
I assume the prosecutor would object. I think it would depend on the case, but I do not think it would be a good practice for any attorney to alter the evidence. But what matters here...
It couldn't be not a good practice for a prosecutor to do that either. I mean, what we're asking now really is you want a rule that says you can't do it. Not, we're going to say it's not a good practice to do it. That wouldn't really help you that much. So is the rule for a defense lawyer, if we do this, going to be the same?
Often these evidentiary rules don't apply exactly equally to the defendant and to others because the defendant is the one on trial.
Well,
So-
how's the defendant being denied a fair trial in this hypothetical, where the defendant is putting labels on things? Where's the damage to the defendant, which I think is what you're trying to get to?
Right.
Where's the error
Right,
that
it's-
we would be analyzing?
Right. I'm not saying it couldn't...
There might be a
possi-
bigger error about the justice system writ large.
Right, but it doesn't go to the defendant's right to a fair trial, and that's why I think that the analysis is different. But if I could, I think my light is on, but if I could just say a word about point one. This case, the Sandoval error in this case was not harmless because there are a lot of things that the defendant could have said that, if credited, would have resulted in an acquittal.
I'm having a little
What was his
trouble-
defense? I thought his defense was misidentification.
His defense was misidentification. But the test that this court set forth in Grant asks, was there anything he could have said that would have made a difference? Did he have critical information, to provide? And in this case, he did, on a number of topics. We discussed intent in our
Was
briefs.
there actually a Sandoval ruling? I was not clear about that from the record.
The court ruled if he's cross-examined, he can be asked about possession of two guns, and then he
Well,
specifically...
that was in connection with, I thought, some Molyneux request by the prosecution, and I think it could be read, it arguably could be read that the judge was saying, when I make that Sandoval ruling that I said I was going to make later in the trial, then maybe this would come in under Sandoval, not under Molyneux.
Well, I
Is
think-
that a fair reading of what the judge said?
I don't think so, because I think if that had been what the court intended, the court would have said, Molyneux, no, Sandoval, maybe, we'll see. What the court said was, Molyneux, no, Sandoval, yes. So I think it's pretty clear that the court actually ruled.
Assuming that's true, when the court did that, which was not what had been previously discussed, and the defense made his position known, when the court turned around and said, okay, I'm going to allow this in on cross, was there any objection?
There was no objection, but the court ruled on the issue.
Well, the court ruled on allowing it in as Molyneux and said it's not relevant to intent.
And
The court had, at that point, hadn't made any ruling whatsoever as to whether it could be used on cross-examination on the issue of his credibility. Doesn't that require another objection?
my recollection of the ruling was that it was kind of part and parcel at the same time. The court said, Molyneux, no, Sandoval, yes. That's a clear ruling on the ultimate issue, and counsel didn't need to revisit it.
The people had never asked for the evidence of possession of the two guns to come in on Sandoval grounds, right?
Not at this, not, correct, not in this proceeding.
And could it even have done so? That is, Sandoval evidence should be evidence of past misconduct, crime, so on. The possession of 2 guns is not necessarily unlawful, right? They were simply trying to get Ms. Perez to say she'd been shown guns on a prior occasion. So would it even have been appropriate for Sandoval?
I don't think it would have been appropriate for Sandoval, and that's, I believe, why
But so the state wasn't trying to get in for Sandoval purposes, and they couldn't have tried anyway. So why would we interpret what the court said as a Sandoval ruling at all?
Oh, the court ruled that it.
I know what it said, but there was no motion and one couldn't have been made.
Well, the fact that the way I view it, and I understand the question, but the way I view it is that the court made a ruling that, for the reasons that Your Honor just mentioned, was incorrect, and the court should not have ruled that it could come in, but it did rule that way. And then the appellate division held that it was an error, and now we're here talking about harmless error analysis, and there was a lot this defendant could have said, among other things about intent, but also about identity. And unlike the situation.
Counsel, do we know whether those guns were legal? He was the discharged DeKalb County police officer. Were those guns licensed in New York?
I don't know the answer to that question. But I can say that unlike Grant, when there was absolutely nothing the defendant could have possibly said, and I would just, as my last words, I'll say, in Grant, there is a footnote that discusses even the possibility that he could have said, oh, I didn't go to the house, I didn't violate the restraining order. The footnote deals with that. There was an alibi witness who turned around. There was nothing that witness could have said. Here we have an error that prevented the defendant from testifying in his own defense, and there were things he could have said, and therefore the error was not harmless.
Thank you, Mr. Dunn. Counsel?
May it please the court, Terrence Heller on behalf of the respondent. The defendant abandoned his Sandoval claim in this case when he did not renew his motion at the end of the people's case, to the extent that the court even made a Sandoval ruling whatsoever. The defendant, in order to preserve a question of law, has to object to the court's ruling. Here, the defendant objected to one thing. The court sustained defendant's objection, then ruled on a second point entirely, and the defendant did not object to that other point, and he never came back to it, although he was afforded ample opportunity to do so. Therefore, the defendant's Sandoval claim is not before this court.
Counselor, can we talk a little bit about the photographs and the question of the altered evidence on that point? Focus you on that for a second.
Absolutely, Your Honor.
Okay. One of the things that strikes me is an underlying policy argument that altering photographs or any evidence at all is the equivalent of allowing unadmitted evidence to go before the jury. That's the core, I think, of the policy argument that the court's presented with. Do you understand what I'm saying here? That when evidence normally comes in, a foundation is laid, it's showed to be material and relevant. The court acts as a gatekeeper, allows it to come before the jury in order to prove a particular fact or series of facts. But if that evidence is altered arbitrarily in pursuit of argument, then that's altered evidence that hasn't gone through that admission process. And that's the policy question before us underneath this, leaving aside ineffective assistance of counsel and those other issues. What do you have to say about that?
There is a distinction between what I would characterize as altered evidence, which is changing the fundamental nature of the evidence and what a particular exhibit means to the jury, and mere highlighting or
I think that makes sense. That's
commenting on
a
evidence.
fair point. You know, Go ahead.
Sorry, Your Honor.
No, you go ahead.
So, for example, there are a lot of examples in this case, but with regards to the phone records, just as one example, the prosecutor showed a slide which contained the unredacted complete phone records with 28 calls or however many calls it had. Then the prosecutor showed a series of slides which had all of the other calls except for particular calls he was referring to in his oral comments up on the side at one time. It's clear that the prosecutor was not altering evidence in that case. He was just highlighting the series of individual calls that he wanted the jury to focus its attention on. And
What were the calls that, on that point, I was just curious about this, were the calls that were not made about that incident by Ms. Perez, were they relevant to anything?
no, Your Honor, they weren't.
So that the jury was kept from some irrelevant phone calls, is that important?
It is unimportant, Your Honor. And if the defense counsel believed that they were important, he could have asked questions of the people's witness on the stand. He could have argued those in his own summation, but the defense was that the defendant was not at the scene at all. He was completely uninvolved. If he was uninvolved, then it doesn't really matter who the eyewitness called in the few minutes before the shooting happened.
What do you think about a rule that would require that there be sort of a pre-screening of PowerPoint presentations?
That would probably be a good practice. I don't know that it has to be a hard and fast rule, but in this
What
case,
about
the
if
prosecutor did show the defense counsel his PowerPoint presentation in advance, and so.
What about if the rule was just limited to, not to, it didn't require, in other words, that the people present their entire PowerPoint presentation, but just those aspects of it that were altered trial exhibits?
That could be a compromise that would work. It might be difficult to draw the line at that point without getting into the arguable accuracy or inaccuracy of these summaries of other evidence that is on the slides that contain text and so forth, but that would be one compromise that the court could come up with.
Did the prosecutor also show the slides in advance to the court? You said he showed them to the defense counsel. What about the court?
I believe the prosecutor only showed them to the defense counsel, and the defense counsel explained on the record that the court asked a question about the PowerPoint, and the prosecutor explained that he had already shown them to defense counsel, and the defense counsel explained that he had reviewed it beforehand. With regards to the slides that were discussed earlier that do contain text, I believe that, as my colleague explained, if an attorney is able to say it, then they're able to show it. And in this
Really?
case,
No. How about the biblical quotes? Do you think you should be able to put a biblical quote on a piece of evidence?
well,
I can see that
in
it's
this case, it's not
argument.
on a piece of evidence.
No, let me finish my point. I mean, I can see it's argument, but it seems to be a clear alteration of the evidence. It's not, you're not pointing out how, where the shell casings are, say, or something like that. It's just oral argument.
In this case, it's not evidence at all. It's one of the rhetorical tools that attorneys have always been allowed to use.
And counsel, I'm sorry,
What
on
did you
that
think,
point,
Trevor?
on that particular slide, the wicked flee, that's not an overlay on anything, right? It seems to me, at least the copy I seem to have is, it's a standalone slide with just the words on it. There's no exhibit that overlays, is there?
That's right, Your Honor. It's just only words on a black
Text,
background.
right?
Yes. So, although attorneys have different styles, there are trials where attorneys rhetorically quote Shakespeare or a civil rights leader or the Bible, and while that's not everybody's style, and it's up to the other party to object if they believe it crosses a line, that didn't happen here. And in terms of how it played in the courtroom, defense counsel would have been in the best position, and although he did not object to the PowerPoint slides, he did object on a number of occasions to the oral comments by the prosecutor, and certainly if he believed that this biblical quotation across the line, that is a sort of rhetorical comment he had been objecting to, kind of independent of the fact that it was on a PowerPoint.
Well, your point, Judge Garcia brings it out, it's not the PowerPoint, it's the alteration of evidence that we should be concerned about. And so if the PowerPoint presentation doesn't alter evidence, then it's fair argument, right?
Yes, Your Honor.
And it's the alteration of evidence that we should be concerned about.
Yes, Your Honor, and I would argue in this case, all of the, I see that I'm almost out of time, but in this case, all of the highlights and insertion of numerals that the prosecutor put on the slides were based on the testimony at trial. The victim testified that he got shot 4 times. He had at least 2 bullets in his body at the time he got to the hospital. And so when there's testimony that I got shot 4 times, the victim has 4 bullet wounds, the prosecutor showed an unredacted chart to the jury as part of the PowerPoint shortly before he showed the blown up version with the 4 numerals there. Those numbers were just rhetorical comment on evidence that was already in the record.
I see. Thank you.
Thank you, Mr. Heller.
Thank you.
Counsel?
Three quick points, Your Honor. First, regarding the phone calls, there was a question about whether or not there was any relevance to the redactions in the phone calls. Defense counsel did refer to the phone records in his own summation. He felt it was important. He highlighted discrepancy between Perez's testimony that she made no phone calls and what the records themselves showed. The redacted exhibit did not include the phone calls that she denied having made, but that showed up on the records.
But were they phone calls from her or from someone else?
I'm not sure, Your Honor. I believe some were. I believe I checked this. Some were from her, but either way, the exhibit should not have been. That should have been for the jury to evaluate. So it wasn't completely irrelevant. Second, I believe the people just said that the prosecutor showed the PowerPoint presentation in this case to defense counsel. If that happened, I'm not aware of it. I didn't see it in the people's brief. My understanding is that, and this is essentially anecdotal, but is that this is a retrial. The jury failed to convict Mr. Anderson at the first trial. That the client told the defense lawyer, who had not been at the first trial, that there was a PowerPoint. And defense lawyer made a record. Essentially, I hear it's a real doozy, or I hear it's a force to be reckoned with. My understanding is that he didn't even decide to go take a look at it. If I'm wrong on the record, but that's my understanding. I haven't seen anything to say that it was actually shared. And the third thing I'd just like to say is the people just said that there's a difference between showing an exhibit that highlights certain things or circles something, circles a lamppost or what have you, but between that and doing something that changes the fundamental nature of the evidence. And I would say that on the medical records in this case, that is exactly what happened. We can go back and forth about the testimony of how many gunshots may or may not have occurred, but there's no dispute about the fact that the records themselves did not say 4 gunshots.
Chief, may I ask a question?
Yes, of course.
Counsel, just to go back for a minute to this, we've been discussing a potential rule that would say you exchange PowerPoints before summation if you're going to use one. what would the standard of our review be if it didn't happen, then you use it, and the judge allows it?
Your Honor, I don't know the answer to that question, and that's not a rule that we've proposed in our briefing. To me, it sounds like it would be a good practice that would solve a lot of problems. But either way, the flat-out rule that we believe is required is you cannot take evidence. People can quibble about whether or not manipulate, alter, doctor is the best word, but you cannot change the evidence outside the presence of the jury and put it before the jury on summation. And reversal is required clearly where the substance of the alterations goes to a key issue in the case. Here, it was intent. Reversal is required. Thank you, Your Honor.
Thank you, sir.